close it.
Okay, Mr. Al-Assadi, can you hear me?
Yes, I can hear you.
Okay, excellent. We're on the record in the matter of the people of the state of Michigan versus Ali Al-Assadi. File number is 22-02662 FT. Council appearance, please.
Yes, Your Honor. Good morning, Assistant Public Defender Stephen Feigelson, appearing on behalf of the defendant, Your Honor. I know this is set for a sentencing. I have not had a chance to talk to him about the recommendations. I can log on to Zoom and do so, Your Honor. For a minute, at least I feel obligated at least telling him what we're looking at here.
Okay, sounds good. Okay, Mr. Al-Assadi, hang tight. We're gonna have your attorney log in and talk to you.
Okay.
Are you ready? Oh, he's on Cooper as well. Okay. I heard there was a Nolly.
You get paid today.
Yeah,
You can step it. Yeah, I'll get the sheet rolled up for you, Brian.
There's none.
For Mr. Cornell, Francis Cornell, Francis.
Oh. Mr. Francis still here? Okay, is Ms. Donnelly not here?
Who's covering that one? Was it Luke? I think Luke Goodrich was covering that one for
Okay.
Ms. Donnelly this morning. I'll check in the hall too. Who does it?
Mr. Goodrich?
Excuse me, Your Honor. Your Honor.
Yes.
I just want to let you know I do have school at 9:30.
Okay, I'm pretty sure you'll be done before then. Mr. Feigelson's logging in now. And your recommendation is not long, okay?
Okay, thank you so much.
No problem.
We up there?
You can be.
You were waiting for me, and I thought.
You're not. I wasn't waiting for you, but what matter are you here on? Walker?
Goss Jr.
Oh, Goss Jr. Is that a plea?
Yes, ma'am.
Do we have a plea sheet and a rights of rights?
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Corey Anthony Goss, file number is 20-03656. Council appearance.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
Good morning, Your Honor. John Abbott, Public Defender's Office, representing Corey Goss Jr. He's present and seated to my right.
Okay, how are you, Mr. Goss? Okay, today's the date and time that is set for a preliminary examination. My understanding is that there is going to be a plea. There's a plea offer. The people are offering to add a count 2 of larceny less than 200. It's a misdemeanor. Maximum penalty, sir, is 93 days and or $500 or 3 times the value of the property. They're willing to dismiss count 1 upon successful plea to added count 2, and there's a killer agreement of no upfront jail. Mr. Goss, I'm talking to you though.
Oh,
Okay, why are you looking over there?
oh no, I didn't know whether to look at you or what.
Yeah, you definitely want to look at me. I'm talking to you.
Okay,
Okay, is that the offer you remember being given by the prosecution?
yeah.
Okay, what was your offer?
Out of here.
$500,
Grandpa, like, bitch, stop driving crazy.
didn't you say?
No, what were you offered to plead guilty to? I want to make sure you were paying attention to me.
Offer to plead guilty. I believe picking them up from the ground.
Okay, so you weren't paying attention to me because, and I could tell because you were looking over there.
Okay.
So the offer is for you to plead guilty to an added count 2 of larceny less than 200.
Okay.
Okay, so that is a misdemeanor versus the felony that you were originally charged with. You recall that?
No.
You don't recall that offer? Oh, well, we'll give you some time to talk to your attorney some more. How about that?
Thank you, Your Honor.
Did you say $500?
I said nothing about, I said that the maximum penalty would be that. I didn't say that that's what you were gonna pay.
Okay.
Okay, you ready, Mr. Feigelson?
Yes, ma'am, thank you.
Okay, we're back on the record in the matter of the people of the state of Michigan versus Ali al-Assadi. Mr. al-Assadi, are you still there? Yes, he is.
Yeah, yes, I still live.
We're gonna get you together so you can get to school on time. All
Okay,
right,
thank you so
so,
much.
no problem. And so, Mr. Feigelson, you've reviewed the precinct's report and recommendation with him. Is there reason to make any corrections?
There are no corrections to report.
Okay, did you want to make any additional or any allocution at this time? I should
I
say.
will briefly, Your Honor, we're supportive of the recommendations of 6 months probation with HIDA. I know what they're asking for, 180-day jail with credit for 1 day, 179 days suspended upon successful completion of probation. I would just ask for the credit for the 1 day. Then if there's any issues on probation, we can address appropriate at that time. Otherwise, we're supportive of the recommendations. It's a young man who I think is going to take all the necessary steps to learn from his mistake and get through this, and keep this off his record, Your Honor. Thank you.
Very good. The report does indicate in favor of you, Mr. al-Assadi, that you scored low risk. It says you're currently employed, you had an overall low risk. And so typically in these types of cases, the recommendation would seek a longer period of time for probation. Yours was only requesting a 6 months term of probation and indicated that status under HYTA would be appropriate. The court will adopt the recommendation of the probation department. You will be sentenced as follows: 180 days in Ingham County Jail, credit for 1 day previously served. The court will suspend the remaining balance of 179 days upon successful completion of 6 months of probation. While on probation, there's a $30 per month oversight fee that you are responsible for. Also, while on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance without a valid prescription. You will be required to submit to random preliminary drug tests and/or your analysis. You have to pay the fee for that, okay, sir?
Okay,
You're not to be at any bars or nightclubs while on probation. You need to continue school. Maintain your employment. And I am going to order that you complete 30 hours of community service. I'm not going to give you a specific timeline on that. It needs to be done before the completion of your probation, okay?
okay,
And the reason why I'm giving you that much time is because you are going to school and you're working. But you do need to complete 30 hours of community service, and you need to get the list from probation as to where you can do your community service, okay?
okay.
Do you have any questions about your probation at this time?
Yeah, where do I go to know, like, for the community service
You'll get that list from your probation officer.
in the mail?
Nope, you'll talk to them. They'll contact you to go over this order, and then you'll have to review and sign it. And then you can find out from them the list of options for where you can do community service to satisfy my order, okay?
Okay.
Okay, there's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost. And then probation at 6 months is $180 for a total of $305 for fines and costs. You can make monthly payments on that, okay?
Okay.
Lastly, I have an advice of rights for probation. It says you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. Except for in cases of domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense was guilty but mentally ill, you may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you complete half the original probation term ordered by the judge. In this case, once you complete 3 months, you can make the request. Your probation officer may, but it's not required, to file a notice with the judge once you become eligible for early discharge. Your probation officer must send to you and to the prosecuting attorney a copy of the notice. The prosecuting attorney then will have 14 days after the receipt of the notice to file written objections to any early discharge. You may request an early discharge on your own from probation after meeting the following conditions. A, you have completed half of the or all the required probation requirements, and you have not violated probation in the 3 months prior to your request. But again, you can't do that until you've completed half the original term ordered. Okay, sir?
Okay.
If a hearing is scheduled, you have the right to hire or retain an attorney for a hearing for early discharge. You would not have the right to court-appointed counsel for a hearing for early discharge. Lastly, you may make a request for early discharge by completing a notice regarding eligibility for early discharge from probation. That's called the NC 512 form. That form is on our court website. Do you have any questions about that?
No questions.
Okay, do you have any questions about your probations or your fines and costs?
I do got a question about my license. Is it gonna be suspended?
It's probably suspended from this. I don't know if he has something else going on.
I don't believe he does. I think what his question is, I think because it's a use, I think there could be a suspension because you're on a height of status
His driver's license.
is not going to be suspended because of the height of status.
Yeah, you're on HYTA status, so your driver's license will not be suspended. And it doesn't sound like you have anything else going on.
No.
Okay, so then you should be all set with your license, but you feel free to follow up with Mr. Feigelson if you have further questions about that, okay?
Okay.
Okay, you're all set, sir, and good luck.
Thank you.
You're welcome. Okay, you also have Mr. Cooper. Did you want to speak to him as well?
I do not, Your Honor.
Okay. We just don't have anybody here to handle Mr. Francis, or did Mr. Francis?
I don't know where Mr. Goodrich went.
Okay, can you step in as just, or can you step in as just a nominee?
Yeah, you do that, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Cornell Francis, file number 21-02202 FBI. Counsel appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, bring on behalf of Mr. Francis this morning.
How are you, Mr. Francis?
I'm good. How are you?
Okay, thank you for filling in, Mr. Feigelson.
No problem, Your Honor.
Today was the date and the time that was set for a preliminary examination. My understanding is that the people are unable to proceed at this time.
That's correct, Your Honor.
None of the defense given this case ready to proceed. I ask that this case be dismissed. Where it'll be without prejudice.
Okay, the case will be dismissed without prejudice. That simply means the case is dismissed today if the prosecution is able to proceed within the statutory time period. The charges can be reissued against you. Do you understand that?
No, what does that mean?
That means that there is going to be dismissed today. It's likely because they don't have a witness. Is that correct?
That's correct, Your Honor.
So if the witness later appears ready to proceed, the prosecution does have the right to reissue the charge against you. You understand that?
Yeah, I understand.
Okay, so we'll get you a copy of this. I will need the name on the top. And then we'll get you a copy of that. You'll be all set. Do you have any questions?
No questions. Thank you.
You're welcome. You're all set, sir. We're on the record in the matter of the people of the state of Michigan versus Anthony Cooper. File number 20-01137 FY, counsel appearance.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Cooper this morning, Your Honor.
Today is the date and the time set for sentencing. And I do have a pre-sentence report, the recommendation dated that it was prepared back on November 8, 2022. Did you review that with him?
I did, Your Honor, and there are no corrections to the body.
Okay, you can proceed with allocation.
Yes, Your Honor, I would ask that the recommendations be adopted today for probation with 7411, Your Honor. This young man has no priors, he's young, and I believe he'll learn from his poor choices in this incident and benefit from the services so he can get the benefit of his bargain and get this off his record. I believe he will be able to do what's necessary. to get this done. Thank you, Your Honor.
Okay. Recommendation, Mr. Cooper, indicates that you scored moderate to low risk and that you would benefit from some supervision. It said you had high risk in companions and moderate high risk in family, intimate partner relationships and personality characteristics and substance abuse domains. The recommendation is for you to be placed on a term of 6 to 9 months of probation with orders to attend and complete a substance use education program and follow the aftercare recommendations. Are you still there, sir?
Yes, ma'am.
Are you struggling to hear me?
Oh, yeah, my phone is kind of low, so I'm trying to keep it to my ear so I can make sure I hear every word.
I'll try to speak a little louder. So the recommendation is for you to be placed on a term of 6 to 9 months probation with orders to attend and complete a substance use education program and follow the aftercare recommendations of the treatment provider. Also to engage in some mental health services and attend and complete BIS program, attend to some random testing and make monthly payments of fines and costs to the court. The court believes, based on a review of the report as well as your prior criminal history, that the recommendation is appropriate, and so I will adopt the recommendation.
Yes, ma'am.
Okay, and so you will be placed on a term of 9 months probation. While on probation, there's a $30 per month oversight fee that you will be responsible for, okay?
Yes, ma'am.
Also, while on probation, you're not to engage in any assaultive or threatening behavior. Let's see where they address 7411.
Recommendations, Your Honor. The last page of the recommendation sheet.
Oh. Okay. I will grant 7411 status. I will not be continuing the no contact order at this time. There is an order for you not to purchase or possess a firearm, ammunition, or weapon of any kind while you're on probation. You're also not to use or possess alcohol, marijuana, or any other controlled substance unless you have a valid prescription. Do you understand that?
Yes, ma'am.
Okay, you're going to be required to submit to random preliminary breath tests and or your analysis testing, and you have to pay the fee that it costs to get that done, okay?
Yes, ma'am.
You're not to be at any bars or any nightclubs while on probation. Do you have any questions about that?
No, ma'am.
Are you still employed?
Yes, ma'am.
Okay. You're being ordered to maintain your employment. I'm gonna order that you attend batters intervention services. And that you get some mental health services as well.
Okay.
You're gonna attend some outpatient substance abuse, and you're gonna follow the aftercare as well, okay, sir?
Yes, ma'am.
Do you have any questions so far about your probationary terms?
Not really. My probation officer is pretty much gonna let me know everything, right?
That's correct. They'll go over this order, and then make sure you get it signed, okay?
Yes, ma'am. I appreciate it.
Okay, so there are some fines and costs that must be assessed. One is a $75 crime victim rights fee that will be assessed. There's a $50 state minimum cost that must be assessed. Placing you on a term of 9 months probation at $30 per month, which is a total of $270. And so your total fines and costs, because I am going to waive discretionary fines at this time, it's going to be $395. You will make monthly payments on that, okay?
Okay.
Do you have any questions about your fines and costs, sir?
No, ma'am.
Okay. Any additional matters for the record today, counsel?
No, Your Honor, thank you.
Okay, you're all set. You'll go over this order again with probation, and good luck to you, sir, okay?
Have a blessed day.
Same to you.
Thank you, Mr. Cooper.
Okay, I did not see Mr. Abbott return. Oh, Mr. Abbott.
Under the television.
Sorry, Mr. Abbott.
Hiding from the,
Okay, let's do it. Let's see, Anthony Embry, whose matter is that? Head of the sentence. No. I see Anthony Embry.
Yes,
Okay, and then there's an attorney here for Pioneer. I don't see their name though.
Yes, I'm here, Your Honor.
Okay, very good. And then let's see who else we have here. Miss Ashley Brown. Okay, very good. And then Mr. Smith is here.
Morning, Your Honor.
I don't see, good morning, let's see here. Oh, Madison Holcomb.
Yes, Your
And I think she posted bond. The bond amount's actually the balance on the judgment. So if the bond, which was cash, I believe, can be released, I can then file a satisfaction of judgment. We can close this case out.
Okay, Ms. Holcomb, it's here. Hold up here. You start your video. Okay. We're on the record in the matter of LAFQ versus Madison Holcomb, file number 17-02782 GC. Council appearance.
For plaintiff LAFQ, Tim Smith, P48259.
Okay, Ms. Holcomb is present via Zoom. She's without counsel. This matter was set for a show cause after bench warrant because you failed to appear back on May, it looks like. And that there was a bond that was posted. Was that for 233?
Yeah, that's the balance remaining on the judgment, Your Honor.
Okay, and so that's the actual balance on the file, which could satisfy and you can get a judgment. You understand that? A release from judgment at this point. You understand this, or satisfaction, I should say, of judgment. You understand that, Ms. Holcomb?
Yes, ma'am. So I would still have to pay that?
Well, you posted the bond. We're gonna release it to the plaintiff and he's gonna get you a satisfaction, okay?
Okay. Yes, ma'am.
Okay. Do you have any questions at this time?
No, ma'am.
Okay, we'll get the satisfaction taken care of and you'll get a copy, okay, ma'am?
Okay. Yes, ma'am. Thank you.
Thanks, Madison.
Thank you.
Thank you, Tim.
Appreciate your help, Your Honor. We'll get that filed as soon as we see the bond monies at the office.
Thank you.
Have a great day.
Thank you.
We're on the record in the matter of the people of the state of Michigan versus Corey Anthony Goss, file number 20-03656. That's Corey Anthony Goss Jr., correct?
Yes, Your Honor.
Okay, we're back on the record in this matter because Mr. Goss needed to further discuss this matter with Mr. Abbott. Do you now understand your offer?
Your Honor, I'll be filing a petition for forensic evaluation,
Okay,
competency to stand trial. I'm working on it right now.
okay, so based on your communications,
Yes,
you believe that that's necessary at this time?
I do. Your Honor. Thank you.
Okay. Any objection from the people?
There are none, Your Honor. Thank you.
Okay. Did you complete the paperwork or are you working on it
I'm
now?
working on it right now. Your Honor.
Okay, very good. Well, once we get that, I'll review it and your client will be ordered to undergo psychological evaluation based on your experience with him and representation to the court. And also my time with him today, I do think that it's warranted to have some evaluation done.
Thank you, Your Honor.
No problem. Any additional matters for the record today?
Nothing from the people. Thank you, Your Honor.
Not from the defense, Your Honor. Thank you.
Thank you. You're all set.
Oh.
They're ready to what?
Plea. Michaelson has Mr. Jones, Yang has Wagner.
James Jones.
No, Mr. Jones.
Mr. Jones.
I have a James Jones. That make me a supervisor on that.
On Mr. Jones.
That's on the 30th.
Hi, who's in the jail?
Hey,
What's your name?
And then
TJ Trine.
check in at the 10:30 matter.
CJ Trine. It's just watching on who the attorney is. Okay, let's do Jones and Wagner.
Quick question.
Yes.
I didn't meet with my lawyer ahead of time. Is there anything going on?
Yep, once I find out who your attorney is, we'll get you in a meeting room with them, okay?
All right, thank you. Cheers.
I'm sorry?
Judge, I represent Mr. Trine.
Okay, I'll put you in a private meeting room.
Thank you.
There's two.
Charisma's iPhone.
Yes, I'm here.
Okay, what's your last name, ma'am?
Palacio, Palacio.
I don't see her on my document. Sorry? Charisma Palacio. Do you have a case number?
My case number is 20L2557102.
You have a pretrial on December 5th at what time? At 9:30.
Oh, okay. Okay, thank you. Sorry.
You're welcome. Sorry, citation. Okay, on the record in the matter of the people of the state of Michigan versus Misty Jones in file number 22-02933. And then I also have the people of the state of Michigan versus Michelle Wagner, file number 22-02935. Councilman Terrence, please.
Brian Ring on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Jones. who's standing to my right.
Okay, how are you, Ms. Jones? How are you, Ms. Jones? Fine. Thank you.
Good morning, Your Honor. Joseph Yang on behalf of Ms. Wagner, who is present to my left.
Okay, how are you, Ms. Wagner? Fine. Okay, apparently, there was an offer extended to Ms. Jones. Was there no offer extended for Ms. Wagner?
There was, Your Honor.
I
I
have
believe
no
she,
paperwork.
I believe she was done, and I believe a vice versa one was also signed, Your Honor.
Okay, very good. Thank you. Okay, it looks like the offer is for the defendants to plead guilty to an added count 2. Although it says added count 1 on
That's what it
here.
is, Your Honor.
Added count 2 of abandoning cruelty to one animal under MCL 750.504A. It's a misdemeanor. Maximum penalty is 93 days and $1,000 or up to $200 hours of community service, and that the people will dismiss count 1. That is a complete and accurate understanding of the offer. It's also Killabrew of Nora Parchian. That's the understanding of your offers.
Yes, Your Honor, the restitution amount will be as well. I didn't break the restitution amount.
Okay, so there is a restitution.
Yes, Your Honor, and I have an invoice from Animal Control with that amount.
What's the amount?
$1,203.
Okay. Okay, so understanding that there is a restitution amount that the people are seeking in the amount of $1,203, you might still wish to accept
Yes,
the
Your Honor.
offers.
Yes, Your Honor.
Okay. Ms. Jones and Ms. Wagner, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, thank you. You can put your hand down. Both of you have the same rights in these files. You have the right in each of these files to proceed to a trial. At the time of trial, you have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to see, hear, or question any of the witnesses the prosecution intends to call. You have the right to call your own witnesses at trial or present evidence that you believe would further defense to this charge. You have the right to remain silent at trial and not have silence be used against you. And you have the right to have the prosecution prove each element of the charge being brought against you. They have to prove each element at trial beyond a reasonable doubt. In order to accept the offer, you'd have to waive those rights today. You understand that, Ms. Jones? Understand that, Ms. Wagner? Yes. And Ms. Jones, you want to waive your rights? What about you, Ms. Wagner? Do you want to waive your rights? Ms. Jones, is anybody threatening you to get you to waive your rights? Were there any promises made to you if you waive your rights? What about you, Ms. Wagner? Anybody threatening you to get you to waive your rights today? No, ma'am. Did anybody make any promises to you in exchange for you waiving your rights? No, ma'am. Are you waiving your rights because you want to today? And are you pleading guilty because you believe you're guilty? What about you, Ms. Wagner? Are you pleading guilty because you believe you're guilty? Yes, ma'am. You understand that a guilty plea could result in a conviction that you may need to report to your current employer or put it on a future job application. Can you speak up? Yes, ma'am. Okay, what about you, Ms. Wagner? Yes, ma'am. Okay. A guilty plea could result in a conviction that may have impact on any immigration status you may be seeking. You understand that, Ms. Jones? Yes, ma'am. What about you, Ms. Wagner? Yes, ma'am. Okay. As to the added count 2 of animals abandoning in cruelty to one, Ms. Jones, how do you plead? Guilty. Ms. Wagner, how do you plead? Guilty. Okay. Actual basis, please.
Yes, Your Honor. Ms. Jones, I want to turn your attention back to June 21st of this year. Were you residing at 1651 Millstone Street?
Yes.
Here in Lansing, Michigan, is that correct?
Yes.
In County, State of Michigan.
Yes.
Well, there you had one animal, is that correct?
Yes.
And you were not properly caring for any animal property, is that correct?
Correct.
What did you do to not properly care for that animal?
Wasn't able to get the vaccines for
Can you speak up, Bernie?
wasn't able to for the litter.
So the cat had no litter, is that correct? Besides no litter, what other, was the animal deprived of food as well?
No.
Just litter, is that correct? Your Honor, I have no other questions for this.
Counsel.
Thank you, Your Honor. Ms. Wagner, I want to take you back on or about June 21st, 2022, 1651 Millstone Street, City of Lansing, Hingham County, State of Michigan. Is that where you lived?
Yes.
All right. And when you lived there, were you in charge of at least one animal?
Yes.
And was that animal a cat?
Yes.
And you've been charged with animal cruelty or abandonment. Can you tell us the condition of where your animals were living in?
They would be poor conditions.
Okay, and what was scattered around the floor?
Pieces.
Okay, and you had not cleaned that up in 2 days, is that correct?
Correct.
And was there a smell in the home?
Yes.
And I don't know if there's any further questions, Your Honor.
Any additional questions from the prosecution?
Nothing on the field. Thank you, Your Honor.
Court is satisfied with the factual basis on each file. I will accept pleas on each file. If on your plea be made freely, voluntarily, and intelligently. This matter is set for sentencing. It's going to be Monday, February 6th at 8:30 in the morning. And that can be via Zoom or you can appear in person in the court, okay? Prior to sentencing, you need to meet with probation so they can provide the court with a pre-sentence report and recommendation as to how you should be sentenced. When you leave here, you need to go right down to the 5th floor to get that questionnaire completed so that they can get you scheduled for your pre-sentence interview. And then, Ms. Wagner, we also need your fingerprint paperwork taken care of today, okay? Okay, do you have any questions for the court at this time?
No, ma'am.
Any additional matters for the record today?
Just one, Your Honor. I can speak to Ms. Jones. We will be here on Zoom. She does wait for her right to be in person.
Thank you.
Thank you, Your Honor. Again, just for the appearance for the sentencing, our intention is to appear via Zoom as well. No further questions, no further issues from the defense on behalf of Ms. Wagner.
Thank you. We're off the record in both files.
Thank you, Judge.
Thank you, Your Honor. Thank you. I'll take it now.
Your Honor, any approach regarding the Hoffman matter?
Okay, and they're gonna bring Jones at some point. Hatton is in custody. Just did Mr. Jones. Mr. Abbott is not hiding. Mr. Abbott, Deon Walker.
Deon Walker is here, Your Honor.
Oh, it's a PCC. What are we doing? Continuing? Mr. Walker. On the record in the matter of the people of the state of Michigan versus Deon Amari Walker, file number 22-02268. Council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Walker. He is present and standing to my right.
Okay, how are you, Mr. Walker?
How are you doing?
I'm doing pretty good. Today was the date that was set for a probable cause conference, because we were waiting to see if you got an attorney, and it looks like you did. And so how are we proceeding?
Your Honor, we're requesting a preliminary examination next week.
Okay, this matter will continue to exam. Did we give you an exam date already?
Not yet.
My notes said that we did, but I don't, it said something at 8:30. What, do we have an exam scheduled for him?
The 16th at 8:30.
December 16th at 8:30.
Okay.
Okay, any additional matters for the record today?
Nothing for the people. Thank you, Your Honor.
Nothing from the defense. Thank you.
Thank you. We'll see you on the 16th, Mr. Walker, okay? Thank you. Have a good one. Let's see. I got some civil stuff here. There's an objection. to some stuff.
Joyce today, he's not, I haven't seen Mr. Mitchell yet. I haven't seen his attorney either. Aaron Robinson's his attorney.
Okay.
I haven't seen him.
We're on the record in the matter of Pioneer Finance versus Anthony Embry. File number is 21-02042. Council appearance, please.
Good morning, Your Honor. Jay Lazar on behalf of the plaintiff, P69480.
Thank you. And then Mr. Embry is present via Zoom without counsel today, correct, sir?
Yes, ma'am.
Okay, today was the date and time set for a motion. There was an objection filed to setting aside a payment or installment payments. We received notice from the plaintiff back on October 6th that you, Mr. Embry, had missed payments on your installment payment plan of March 2022, April 2022, May 2022, June 2022, July 2022, and August 2022. And we received a response from you indicating that you did not receive this notice until October 13th by mail, and that you had been laid off from your job at Ryder 4 times this year, and due to this, you were unable to make your payments. You are requesting, stating that as of today, you can make payments of $50 per month. And that was all that you can afford due to your income and written bills at this time. Does that accurately reflect your response, sir?
Yes, it to add to the record, they just announced that, you know, in my job that they're gonna be getting us laid off on the 23rd. So I'm gonna make $100 payment on next month, because we're gonna be laid off for to the 23rd to the January 17th. This month for the $100 payment, not next month. I'm sorry. This month and the beginning of next month.
Okay. And so did you have an opportunity to speak to Mr. Embry privately today, counsel?
Your Honor, I already talked to Mr. Embry and we gave him the opportunity to catch up and he wasn't interested.
Okay, I don't know that it sounds like he's not interested. It sounds like he's not in a position to do that is what it sounds like. Is
Exactly.
there's no ability to work with him while he regains some stability in his work?
Your
Is that
Honor,
what you're saying?
Your Honor, if you look at the record, the past on this, it's been pulling teeth on this file from the start. We couldn't get the pretrial statement back. He didn't want to return the consent judgment. If you go through the history of this file, it's been fighting him tooth and nail for everything. We've appeared many times. My client does not believe There's been no payment since February, Your Honor. He's been working since then. My client does routinely check.
My records.
If at this point
my
he's not
records-
working, if there,
My records do not reflect what you're saying. It says here you guys met in September 20th, 2021, and completed a joint pre-sale statement. Then he returned to court again on December 6th. And you guys agreed to the amount in the complaint, and there was a consent judgment filed. I don't have anything else.
Your Honor, we had
in my-
to do it
I
under the
don't
7 day.
I don't have anything else in my file that reflects what you're saying. And so my question is, the only thing I have is that this year, he's not been able to make his monthly payments of $50, which is what he is not contesting. He's saying he's been laid off. I asked a simple question. Is your client willing to give him an opportunity to restart these payments in January?
Your Honor, no. Unfortunately, my client has tried working with him in the past, and every time payments do not come in, just like no payments have come in since February. My instructions today were to have the order set aside so we may move forward.
Okay, thank you. Okay, well, unfortunately, Mr. Embry, there's nothing the court can do within the realms of the law to avoid this for you. I sympathize with your situation, and I recognize you're trying to take care of your children and keep your bills afloat, but this is a bill that you have to prioritize as well. And so if the stability at your current job is not allowing you to do that, then you probably wanted to consider alternative employment, because they're going to continue to seek their money under this judgment, and they have the right to do so. And so the request to set aside the installment payment order is going to be granted because you have not been consistent this year, and you've already missed over 6 payments.
So what did you catch those?
Doesn't mean that in the future you won't be able to.
But what if I can catch those the 6 payments up within 2 months?
It doesn't sound like they're interested in that, sir.
I mean, then what I'm supposed to do? I'm paying a mortgage and I'm catching up on bills and stuff like that. So just put that to the side just to pay these people off.
Well, this is a bill that you accrued, sir.
Yeah, I know that. And I'm still willing to pay it.
Right, so you have a responsibility to pay it.
You're right.
So they're not willing to work with you any further because of the amount of times that you've missed payments.
So were they gonna garnish you then?
So would they want to garnish me or what?
That is what they're gonna seek next, I'm sure. They're going to seek to garnish you.
All right.
Okay, that order will be entered as of today. Any additional matters for the record?
No.
No, Your Honor.
Okay, thank you. You're all set.
Thank you. Everybody have a nice day.
Thank you.
Yeah.
We're on the record in the matter of Credit Acceptance Corporation versus Ashley Brown, file number 22-01353 GC. Council appearance.
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
Today was the date and time set for a pre-trial. Did you all complete a joint pre-trial statement, or did you come to a resolution?
We completed the joint pretrial statement. Defendant requests copies of documents, so we do need the discovery.
Okay, well, the discovery period will be, I'm sure, addressed on the joint pretrial statement. Are you able to, did she give you permission to sign the joint pretrial statement so you can send it to us, or does she want to review it first?
Ms. Brown?
I'm okay with just signing it.
Okay, very good. And so, Ms. Olivia, if you can provide us with the joint pretrial statement, I'll review and sign it, and then we'll get you a scheduling order that will also address the time frame for which discovery is to be completed and your future court dates, okay?
Okay, so just for clarification, I am to sign the defendant's name and state with permission on the record?
That's correct.
Okay. And then we'll submit.
Okay, and you can send that via email to Judge Simmons Courtroom at lansingmi.gov. Ms. Brown, do you have any questions today?
I do not have any questions at this time.
Thank you so much.
Thank you. You're all set.
Have a good day.
You too. Bye.
To you both. Okay, what do we have?
My guy's still in custody.
Okay. Who, James Jones?
Yeah.
Tyler Hatton, what's going on with that?
Rick wasn't switched up from tomorrow.
The writ was not switched over?
Yeah.
Who was responsible for that? Okay, so he's not gonna, we don't need him to come tomorrow.
No, we're gonna.
Oh, okay. Who's his attorney? Mr. Austin?
Yeah, very close.
Okay. Hatton. If we use that one to be reset, Patrick Barnes. Okay.
Right on that one, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Patrick Gordon Barnes, file number 22-03063, council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. Jeff Chip on behalf of the defendant, Mr. Barnes, who is standing to my right.
Good morning. How are you, Mr. Barnes?
Good.
How are you, Mr. Chip?
I'm good, Your Honor. Thank you.
Today's the date and time set for a preliminary examination. I do have here a nollie that's indicating that the people are unable to proceed because the necessary witnesses failed to appear. So they're moving to dismiss this case without prejudice. So this case will be dismissed today. And they have the right to reissue the charge if the necessary witnesses later re-engage with the prosecution's office and they're ready to proceed. Do you understand that?
Yes, I do.
Do you have any questions today at this time?
No. I have one question, Your Honor. There's two counts on this complaint. One is the felony count. One is the domestic violence. It's my understanding both are being dismissed because there is a bond condition. He can't return to his home. I just want to make sure that he would be in any kind of violation of any bond condition.
Count one and count two are both here to be dismissed, but you probably want to give us 72 hours to get that out of lien.
You got it, Your Honor. Thank you.
Okay, any additional matters for the record?
Nothing further.
Nothing, people. Thank you, Your Honor.
You're all set. Need your copy.
Thank you.
We're on the record in the matter of the people of the state of Michigan versus Avina Lopez. The file number is 22-03137FY, council appearance.
Brian Ring on behalf of the people.
Attorney Aaron Schroeder on behalf of Ms. Lopez, who is present and standing to my right.
How are you, Ms. Lopez?
Good.
Today was the date and time set for a preliminary examination. I have a knowledge here says the people are moving to dismiss without prejudice because the necessary witness failed to appear. That's including the case will be dismissed today. They do have the right, however, to reissue the charge against you if the necessary witness contacts them and is ready to proceed. Do you understand that? Sorry?
Yes.
Okay, do you have any questions? Okay, let me get this signed for you and you can get a copy and then you'll be on your way, okay? Additional matters for the record.
Nothing, people. Thank you, Your Honor.
Nothing for the defense, Your Honor. Thank you.
Thank you, you're all set. Ms. Shelton,
Yes, Judge.
are you ready with Mr. Trine?
I am.
On the record in the matter of the people of the state of Michigan versus TJ Lee Trine. File number is 20-02985FY. Can I have your appearance for the record?
Yes, Tiffany Shelton with the Hingham County Public Defender's Office here on behalf of Mr. Trine, who's appearing via Polycom from the Hingham County Jail.
Thank you. Today was the date and time set for sentencing. I do have a updated report from probation. It's dated for October 14th, 2022. Did you have an opportunity to review that with your client?
I did, Judge.
Okay, the recommendation there was for him to serve a term of 90 days. There was at that time a credit for 65. It's been over 30 days since then. Any additions or changes that should be made to that report?
Judge, I would dispute the amount of jail credit that's listed on the updated report. There was a report that I received back in August that was dated March 29th of this year, indicating that Mr. Trine had 22 days of credit. And then back in June 23rd of this year, he was arraigned for his failure to appear. He spent about 25 days in jail. And then this most recent time, he was taken into custody October 6th. And then from October 6th to today, that'd be 57 days credit. So I have his credit at 104 days, not the 65 that's listed in the report.
Let's see here. I'm trying to understand how he would have gotten credit for 22 days as of March 29th. Because he had a PR bond and he was originally arraigned. And then we didn't get him back in custody, it looks like. Oh, okay, I see. February 18th. Should have had 22 days. Continue to examine. When did he go back in custody after that?
My records indicate that he was arraigned on June 23rd of 2022. And according to the court's website, the bond wasn't posted until July 18th of this year. So that would be 25 days.
Okay.
And then taken back into custody this current time, October 6th.
Okay, so your total credit that you have calculated is 105 days?
I have 104 days.
104 days, okay. Okay, we can update the credit. Did you want to make any allocation at this time?
Yes, thank you. I discussed the updated report with Mr. Trine. He's in agreement that he's not a good candidate for probation, and that's based solely on his financial situation. He's homeless, so he doesn't have stable housing, and he also has no income, so he doesn't have any stable income to pay, oversight fees, the cost of treatment, things like that. So we would ask the court to follow the recommendation for a term, a jail sentence, essentially with credit for time that he's already served. I would indicate to the court that while in custody, he has been participating in the CATS program for about a month now. He's attending NA classes, a class regarding coping skills. He's participating in group therapy as well as one-on-one therapy. So I think the 90-day recommendation is appropriate, and I would ask the court to give him credit for the time he's already served. Thank you.
Thank you. I will adopt the recommendation. I will give him credit for time served and waive discretionary fines. I don't think that there was restitution on this. So no one provided it to me, so no restitution will be ordered at this time. Any additional matters for the record today?
No, Judge, thank you.
Okay, you're all set for today, Mr. Trine. Good luck.
Thank you.
No problem. You can let the deputy know you're free to go.
Yes, ma'am. Thank you. You have a great day.
Same to you. Okay. Ma'am, are you waiting for someone? Oh, James Jones. Okay, I think you're gonna bring them up shortly. Okay, sounds Who's in the jail? Can you hear me in the jail?
Yes, I do.
What's your name?
My name is Andres Morgan.
Okay, sure. Morgan, Andres Morgan.
Oh, Andres Morgan.
We're anticipating a waiver to circuit court.
Okay, sounds good. And there was someone else that we were ready on?
Mr. Martin's in the courtroom for sentencing.
Okay.
And Miss Robinson is here on Mr. Mitchell's case. Should be fairly quick as well, Your Honor.
Mitchell,
Evan Mitchell, Your Honor?
Evan Mitchell, and then we have Sean Martin. Okay. You're on Morgan.
I am, Your Honor.
Get him out of here. On the record in the matter of the people of the state of Michigan versus Andres Morgan, file number 22-03131, council appearance.
Thank you, Your Honor. Randall Berman on behalf of the people.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Morgan. He appears with us today remotely from the Ingham County Jail.
Okay, Mr. Morgan, today's the date and time set for a preliminary examination. My understanding, though, is that there's going to be a waiver to the circuit court. Is that correct?
Yes, Your Honor.
My understanding and anticipation, yes, Your Honor.
Okay, was there an offer at all?
Yes, Your Honor. People unconditionally waive their right to have a preliminary examination. My understanding the defense does as well. The offer as it stands now, Your Honor, is for the defendant to plead guilty in circuit court to a reduced charge of home invasion, 3rd degree. Negotiations will continue in circuit court. There is an agreement with regard to the charging language, Your Honor, and that will be as it pertains to count 1, that it shall be filed in circuit court with an information that will read with the intent to commit an assault and or resist, obstruct, oppose a police officer. I'm adding that as part of the count 1 language, but otherwise people waive the right to have a preliminary examination. Thank you.
Okay. I'm Strauss.
Yes, Your Honor, that is correct. I have no objection to the modification in the charging language. Count 1, the pending offer is for reduced charge of home invasion 3rd, and we will continue to pursue negotiations at the circuit court on that. And my understanding and anticipation is Mr. Morgan is willing to waive the circuit court with that pending offer.
Thank you. Mr. Morgan, do you understand that you have a right to have a preliminary examination in this matter in the district court?
Yes, I do.
You understand that the purpose of the preliminary examination is to have the prosecution put on evidence to establish that there was sufficient probable cause that a crime was committed and probable cause to charge you with the crime. You understand the purpose there?
Yes, I do.
And do you wish to unconditionally waive that examination today?
I just have one question. Was the habitual information dismissed also?
Still pending, sir.
You say what?
Your Honor, if I may.
Yes.
Mr. Morgan, the pending offer does not include any habitual offender notice. It will be bound over as charged, but the pending offer is just to the home invasion 3rd charge with no habitual offender notice.
Oh, okay. What about the obstruction?
It all gets bound over, Mr. Morgan. That is the pending offer that we are waiving up on that we discussed.
Okay. No habitual offender information is going over the circuit. Is that correct?
No, it's all going over to the circuit. That's the thing. Everything gets bound over, but your offer right now would be for you to plead guilty to an additional charge of home invasion 3rd degree, and there will be no habitual offender notice if you take that offer. But everything is getting bound over as charged if you waive. You understand?
Yeah, okay, thank you.
Okay, very good. And so do you want to waive your examination today to have this matter sent to the circuit court?
Yes, I do. Yeah.
Okay, is anybody threatening you to get you to waive your examination, sir?
No, ma'am. No, ma'am.
anybody make any promises to you in exchange for you waiving your exam?
No, they did not. I'm doing it on
You're
my
waiving it
own free will.
freely and voluntarily?
Yes, I am on my own free will.
Okay, very good. This matter will be bound over to the circuit court for a bind over date of December 14th. You do not need to appear in court on December 14th. That's the date they'll get the file from this court, okay?
Yes, ma'am.
Your next court date will be a pretrial. You and your attorney will be made aware of that court date, okay, sir?
Okay, ma'am. Thank you, Your Honor.
Okay, no problem. Do you have any questions today?
No, you answered everything and so did he, my attorney. I appreciate it.
No
And I
problem.
appreciate-
Bond was set.
Okay, I
No
appreciate
problem,
the
sir.
pro-
Thank you.
Okay. Appreciate the prosecutor for offering the deal too.
Sounds good. Bond was set at 10,000 cash surety. That will continue. Any additional matters for the record, counsel?
No, Your Honor, thank you.
Nothing, Your Honor. Thank you.
You're all set, sir. Thank you. Thank you, sir.
Thank you. Have a good day.
Okay, let's see. I did that one already, did I not? Okay. One's Smoking's all set. Mitchell. Yes, thank you. For the record, in the matter of the people of the state of Michigan versus Evan Patrick Mitchell, file number 22-02861, council appearance.
Brian Ring on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Mitchell.
Today was the date and time set for preliminary examination. Is Mr. Mitchell here?
He is not, Your Honor. I doubt that he will be here today. I have very limited phone contact with him. He doesn't have access to a good working phone number. I believe it's like an internet number. And when I do call him, he answers, it's only about a couple minutes of communication at a time. I'm not sure with the date change that he received notice of the new date.
Well, you would have been told at his PCC of the date change.
I believe he showed up on Zoom for like 2 seconds at the PCC and then disappeared.
Okay, yeah, that looks like that's happened.
So
At
and
least
he did
3
turn
times.
himself in, Your Honor, I believe a day or two after that, and then was given the date for tomorrow, and then it was changed.
Yeah, November 4th, he appeared in via Zoom, didn't stay for the court to address, and then he left. November 10th, did the same thing. Sounds like he did the same thing on December 1st, so I think he knows what he's doing at this point.
Well, I guess I would just ask if notice was received or sent to him.
Well, he would have been notified for these previous dates when he was logging in and dipping out. Notice would have been sent for him to appear today because it says it was mailed on November 22nd.
Okay, and that was for today's date, not the December
That was
2nd
for
date.
today's date.
Okay, thank you, Your Honor, I understand.
All right, so a bench warrant will be issued, and we'll see if we can regain communication with him. I'm happy to hold it for 48 hours.
Thank you, Your Honor.
No problem. Mrs. Jones? Who are you waiting for on that?
Everybody walked out, but he was speaking around the phone.
We have 0 prosecutors. Okay, I have a sentencing I can handle. Let's see. Ms. Martinez, how are you?
I'm great, Your Honor. How are you this morning? Good morning.
I'm doing pretty good. Which matter are you here for?
I'm here for sentencing for Jabril McCollum.
We're on the record in the matter of the people of the state of Michigan versus Jabril McCollum and file number 22-01756FY. Can I have your appearance for the record?
May it please the court, Deborah Martinez on behalf of Jabril McCollum, who is present via Zoom.
Okay, how are you, Mr. McCollum?
I'm doing good, Your Honor. How you doing?
It's really low on your end, but I think you say you're doing pretty good.
Yes, ma'am. I'm doing pretty good. How you doing?
I'm doing pretty good myself. Today was the date and time set for sentencing. I do have a pre-sentence report here. It's been prepared on November 9, 2022. Ms. Martinez, did you get that report?
I did, Your Honor.
Any additions, corrections, or deletions?
A few, Your Honor. Mr. McCollum has a visual impairment, so today I read it to him and we went over that together. The first correction would be on page 1 under risk scoring, personal history, and impression. The second paragraph, Mr. McCollum does now have a medical marijuana card since the date of this interview. So with that second paragraph, last sentence, which says he does not presently possess a medical marijuana card, he now does possess a card.
Okay, very good.
Let me go through my other notations here. And as far as the report of substance abuse assessment, on the second page of that assessment, the third paragraph down, which starts with he first used prescription opiates that were not legally prescribed for him, was in 2016. That should note that in 2016, he was legally prescribed Norco due to being shot in the leg. So he did have a legal prescription at that time.
Okay.
And on that same page, under employment, education, and family history, the second paragraph, last sentence says he has his son 3 to 4 times a week and has joint custody. Mr. McCollum now has full custody of his son Trayvon and has him 24/7 all of the time.
Okay.
And those are all the corrections. Thank you.
Thank you. We will note, those updates have been noted. You can proceed with allocution.
Thank you. Your Honor, before you is Mr. McCollum, who is here on a misdemeanor for use of cocaine. I noted from the probation report that the full police report was added to the file, and it should be noted that at the time of this offense, Mr. McCollum was living with his brother. And over these last few months, I've had a chance to get to know Mr. McCollum a little better. And I think that part of the reason that he has gone astray is when his mother and father passed, he promised he would take care of his little brother. And we've come to recognize now with what his brother was doing out of the apartment, that that is not something that can go forward any longer. He cannot live with his brother. He has since separated residences from his brother, lives with his sister, who is a much better influence on him and supportive for him and his son Trayvon. He never took Trayvon over to that apartment where his brother was. When he was spending time with Trayvon during that period, it was always away, which is why on the day the police were doing their stings and sending informants, Mr. McCollum, Jabril, was never there because he was always away spending time with his son. He has used cocaine. He does not have a healthy coping system. And I think unfortunately, we see this in the community way too often. We have someone with a disability who cannot work. We have someone who has endured some trauma. His father passed away in his arms when he was a teenager. He was accidentally shot in the leg by someone only a few years later, and the bullet is still in his leg and he has constant pain. And I think what we're seeing here is him using these substances to really, in an unhealthy way, numb or negate the pain of life or the physical pain that he has not learned to do in a healthier manner. But now life has changed. The mother of his son is in prison for at least 3 years before she's eligible for parole. He is now in the role of having to be a full-time dad to a 3-year-old boy. And he has an opportunity right now to break that cycle for that little boy. We have talked about probation. For him, and I know he will tell you this too, Judge, he is terrified of failing you on probation, not because he can't do the counseling or he's worried about the drops or being able to learn to cope with the traumas and the triggers in his life in a way that does not involve controlled substances, but due to his disability and his current situation of living with his sister and not having a home of his own with his son, he is terrified that he will fail you in that he will not be able to afford the oversight costs or the fees associated with drops. He's terrified to the point where he even asked me today, is there a way I could do weekends so my sister could watch my son, because I don't want to be violated on probation and let her down. So I told him we needed to be candid with the court about those costs and those worries about failing probation for financial reasons versus reasons of him really wanting to move forward in a positive light. He has applied for Section 8 housing on his own so he can maintain his own residence for his son. He is currently on the waiting list for that. And he has that bench warrant out of Eaton County for being an unlicensed driver, which he intends to take care of after this matter today. He had other driving matters we also took care of for him as a courtesy to try to help Mr. McCollum get back on his feet, especially this time of year with the weather and the holidays here. I do think Mr. McCollum is a really good person, and I think he tried to keep his promise to his parents to take care of his brother, but now that little boy is the person he has to take care of. And taking care of that little boy means taking care of himself and being a man and coping in a healthy way with everything that life has given him. So we would ask that you suspend any jail time at this time. If there is anything Your Honor can do in regards to this fear he has about being violated because he will not be able to pay the cost, I don't know what the opportunities are there, but if there are some, I would ask that you consider them. And then hopefully we can get Mr. McCollum on the road to being a strong man, a good role model for his little boy, especially with mom no longer in the picture. Thank you.
Thank you. And thank you for, providing that in-depth allocution. I mean, it really sheds light into how we got to where we are today. And it helps me understand your client, Mr. McCollum, better, and how to better provide a resource for him so that we don't continue to be on this path. I think, Mr. McCollum, you're in a position where you can make a great positive turn. And I understand that you have this fear about of failing probation. I'm not putting anyone in jail for not having the ability to financially afford probation. I would never do that. But I'm now also not going to just put you in jail so that you can get it over with, and then you still have this underlying issue lingering. That's a disservice to you. It's a disservice to your child. It's a disservice to this community. And it's only going to put you in a position to be right back here when situations reach their breaking point again. So it's my goal, and that it should be the goal of the justice system, to try to make you whole and get you the tools that you need so that you can be productive and that you can be able to garner strength from other areas moving forward. And I recognize you have some traumas that need to be addressed. You're going to have to do some work on your own to address those. But there are some things that I can put into place in order you to do and monitor to make sure that you're taking positive steps. And so that's what my intentions are, sir. So to the extent that I'm going to put you on a term of probation, I am going to put you on a term of probation. You scored at a moderate high risk in several domains. And so judicial intervention is appropriate. And so you do need some mental health counseling. You do need some substance abuse counseling. We'll see if probation can work with whatever insurance you have to try to find outpatient services that would be covered by your insurance, so that won't be a large out of pocket expense for you. The recommendation is for you to do a 12-month term of probation. I am going to adopt that. At the end of this sentencing hearing, I will advise you of how that can be cut in half. And so you don't need to be fearful of having a 12-month or full year. You can probably get this done in 6 months if we don't have any violations that are not related to money. How about that? Okay.
Yes, ma'am. Yes, ma'am.
Okay. And so there'll be a 12-month term of probation. I am going to order that you participate in mental health services, and that can be done through a private entity, or you can get it through community mental health, whichever is more suitable for you. But you can get with probation, and they can provide you with some recommendations on that.
Okay.
Your Honor, can I ask, will Mr. McCollum get an opportunity to speak on his own behalf?
Absolutely. If that's what he wants, he can speak at this time.
Yeah, Honor, I'm sorry about the inconvenience of the whole situation.
Can you speak up a little bit, because your volume is really low?
I'm sorry. I'm sorry about the whole situation of the inconveniencing you like this. I really am trying to get up on the good foot. It's just the trials and tribulations. I am not gonna lie, it has been taking a toll on me. Honestly, with me having my son a lot more, there is no more idle time. I just feel like I gotta focus a lot more and nail it down. But yeah, as far as my son, I really need to be there with him. So that's why I do appreciate you giving me the opportunity to at least be there.
Thank you. And thank you for making that statement. You do not owe the court an apology. You're not inconveniencing me for me being here. This is why we're here. This is a service. We're here to provide the service to the community so that we can try to restore and give you the attention that you need, that you haven't taken on your own, so that you won't end up back here for similar or worse criminal activity. And so again, you know where you need to be, and it's with your child, but you also need to be healthy for yourself. So the only apology that's owed is to yourself for not taking care of yourself or not knowing how to take care of yourself. But no need to beat yourself down. There's opportunity and there's hope that you can pull yourself up and that you can do better and that you can be positive for your son, which he needs you more than anything right now if he doesn't have his mom there. So you sitting in the jail is not helpful.
Right.
Okay, so again, I'm ordering you to do some mental health counseling. You can do that through community mental health. If you're already engaged in mental health counseling, you'll just need to provide that information to your probation officer, and that will satisfy that portion of my order. I'm going to order that you participate in outpatient treatment. Again, if you have health insurance, let your probation officer know so they can try to work with that insurance to find out what services could be ordered that will not cost you out of pocket, but will be covered by your insurance for the outpatient services. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol, marijuana, or any controlled substance unless you have a valid prescription. Are you clear on that portion of the order?
Yes, ma'am.
You will be required to submit to random preliminary breath tests and/or your analysis testing, and you need to pay the fees that's responsible for getting that done. You're not to be at any bars or any nightclubs while you're on probation. Do you have any questions so far?
No, ma'am. Just how much would the drops be?
I think the drops are about $10 or $11,
Oh, okay.
I believe. But there is a one-time fee to set it up. And so you would be responsible for that. There's an oversight fee as well for probation. That's $30 per month. You don't need to prioritize that. You need to prioritize your drops at this time. And at the end of your probationary period, if all I'm dealing with is that you didn't make your monthly payments on the oversight fee, I can deal with that in another way. But what I can't deal with is if I'm not able to see what's going through your system and to make sure you're not putting any contaminants in there. So that you need to prioritize in order to remain compliant as far as I'm concerned, okay?
Yes, ma'am. Yes, ma'am.
Okay, and are you employed at this time?
No, ma'am.
Okay, and is that because you're not able to be employed?
Yes, basically, I'm legally blind.
Okay. Okay, and so again, as to fines and costs, there's a $30 per month oversight fee that will be assessed while you're on probation. There's a $75 crime victim rights fee that will also be assessed, and a $50 state minimum cost. I'm going to waive discretionary fines and costs. Your total for fines and costs, including the probation oversight, amounts to $485. Again, I want you prioritizing your preliminary breath test and or your analysis testing during this time, and at the end of probation, I can deal with that final amount for you, okay?
Yes, ma'am. Yes, ma'am.
Do you have any questions about fines and costs or probation at this time?
No, ma'am.
Okay. You're gonna need to meet with probation so they can go over my order, and then you'll review that order, sign it and get it back, and then you'll get your date and time in which you're supposed to report monthly to probation, okay, sir?
Yes, ma'am. So
There's an advice of rights for, I'm sorry?
I was, do I have to report once a month or twice a month or?
You'll report to probation once a month. They'll give you the date and time that you'll be reporting, okay?
Okay.
Okay, and so there's an advice of rights for probation early discharge. It says here, you have been sentenced to a term of probation in the 54A District Court. The conditions of your probation have been individually tailored and are specific to address your assessed risks and needs, except for cases of domestic violence, criminal sex crimes, stalking offenses, or an offense where the defense of guilty but mentally ill was asserted. You may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you have completed half the original term ordered by the judge. Your probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must then send to you and to the prosecuting attorney a copy of the notice. The prosecuting attorney has 14 days from receipt of the notice to file written objections to early discharge. You may request an early discharge from probation after meeting the following conditions. A, you have completed all of the required probation programming, and B, you have not violated probation within the 90 days preceding your request. You must send a copy of your request to your probation officer and to the prosecuting attorney, and the prosecuting attorney has 14 days from the receipt of the notice to file any objections to your request for early discharge. If a hearing is scheduled to address the request, you have the right to hire or retain an attorney, but you do not have the right to court-appointed counsel for a hearing for early discharge. Lastly, you may make a request for early discharge by completing the notice of eligibility for early discharge. That's called the NC 512 form, and that's available on the court's website, or you can just ask your probation officer for the form, okay?
Okay.
Do you have any questions about that advice of rights?
Oh, man.
Okay. I think you're gonna be just fine, sir. I don't want you to be fearful of failure, because then you'll have some self-fulfilling prophecies you'll have to deal with. Think positive, think success.
Yes,
You're
ma'am.
gonna do this, you're gonna be fine.
Yes, ma'am.
Okay, unless there's any questions for me or any additional matters for the record, you're all set. Okay, and good luck.
Thank you.
Thank you, Your Honor.
Thank you. You got it? Okay, we have Mr. Fisher on here, and then
I think we're ready on Mr. Jones.
okay, we're on the record in the matters of the people of the state of Michigan. Mr. Bible is not here.
I'm gonna stand in for Mr. Ferguson.
Okay, sounds good. Versus James Jones. I have file numbers 22-03029 and 03034 FY council appearances.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
And good morning, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Jones, who's standing to my right. I will note I'm filling in for Attorney of Record Stephen Feigelson.
Thank you. How are you, Mr. Jones? Okay, we're here on two files. One for unlawful imprisonment, assault with intent to do great bodily harm, less than murder. There's another one of domestic violence and interfering with the crime report, which is the date and time set for preliminary examination on both files. And how are we proceeding?
Your Honor, Mr. Feigelson contacted me yesterday evening and informed me that Mr. Jones was firing him and retaining his own attorney. This is in line with what people observed on the defendant's jail calls. And as a result, Mr. Feigelson told me I could call off my witnesses for today, because that's what happens when your client tells you you're fired. So I believe that that may or may not be happening this time. Mr. Feigelson is still on the record with the circuit court, as he has been for the last hour. Mr. Palmer was flagged down at Mr. Feigelson's request of someone from his office step in for him. I know he's been speaking with Mr. Jones. I leave it to him to say how we're doing this tonight.
It looks like there is an emergency hearing on this to revoke phone privileges.
That is correct, Your Honor. The week that you were gone, we had Judge Buchanan hold an emergency hearing. That was on the 17th, because 30 plus jail calls were discovered to the victim, telling the victim not to come to court. He was also calling his mother, having his mother send messages to the victim, have the victim not come to court, and things of that nature. As a result, Judge Buchanan revoked his phone privileges in their entirety until he was able, until you were back and able to address them. That is the timeline.
I'm sorry, somebody speaking in the court without permission? Okay, because contempt orders are real.
But that is the timeline that Judge Buchanan set up for her order.
Okay, so Mr. Jones, you are not satisfied with your representation by Mr. Feigelson?
I feel like what I was telling him, like every time I met with him, like it was always a heated conversation, but I just felt like he wasn't representing me right. Like I told him, if you're not gonna do what you're gonna do, then you need to go. But I felt like this when not got a ran on my charges, I did contact my baby mama because I felt like I felt like because I thought I want to talk, I want to say something, I want to tell her something.
Yeah, but he's just trying to get you from saying something that, you know, can be used against you. You have that right to remain silent. So at this point, you're not ready to put it on the record. Prosecutions are taking copious notes, just so you know. Yeah, I'm asking you about representation. I'm not asking you about any violations of the court order.
I can say, and Mr. Jones is free to speak if he wants to, but I will say I've had an opportunity to sit down with Mr. Jones and discuss the matter a little bit. Certainly, I just met him this morning. It does sound like there is a breakdown in the attorney-client relationship between Mr. Jones and Mr. Feigelson, and it's my understanding that Mr. Jones intends to hire his own private counsel to represent him in both of these matters.
Have you already made inquiries as to private counsel?
No.
I don't believe he has, Judge, and I think the other issue, part of the issue is that he's got a little bit of difficulty in doing that right now because he doesn't have any phone privileges, so he can't make phone calls from the jail for the purposes of hiring or retaining counsel. But I think that my understanding today, at least in speaking with Mr. Jones, is that his request is to adjourn today's preliminary examination, to retain his own counsel, and to have that new counsel on board in both files with enough opportunity to conduct the preliminary examination or to at least meet with Mr. Jones to determine how they are going to proceed with the preliminary examination.
For the record, Your Honor, that order had to stop Mr. Jones from making calls from the jail.
I think the order was that he could make contact with his attorney. I'm sure he could make contact with any attorney, right?
So I mean, he's been calling his mother from other inmate accounts.
Judge, I'm standing in this morning, so I don't have any way to respond to that. I don't know all the history or detail of it.
Okay, sounds good. One day the word's gonna get around in the Ingham County Jail that Mr. Pfeiffer is listening to jail calls. And people are gonna stop thinking they're smarter than the system one day. But I guess that's not today. You're gonna make some calls for an attorney. Has your mom made any calls for you?
No, Your Honor, cause I can't call nobody. I had some people call, like, can you call my mom for me and talk to her? But
what about an attorney?
No, yeah.
When you spoke to your mom, did you ask her to find you an attorney? Okay, did you have money to pay for the attorney? I'm sorry?
No.
What's your plan? How you gonna pay for the attorney?
My mom is gonna get it for me.
You who?
My mother.
Oh, your mom's, is this your mom here?
Yes.
Ma'am, what's your name?
Jacqueline Pearson.
Jacqueline Pearson, you've been in contact with an attorney for your son?
Not yet. You told me to, when his friends told me to pay. He wants one, so I'm gonna work on it, but I got a question for you. How long can I work on it to get him a lawyer or get another court appointed?
So he's got to get form shop inside the public defender's office. He got appointed a public defender. He does not satisfy with them. So he's going to have to hire his own attorney I'm going to withdraw or allow Mr. Feigelson to withdraw his representation due to the breakdown there. And so I need you to tell me when you're going to hire the attorney. He's the one who has the right to speedy trial, but he's tolling that right himself by doing this.
As I leave here today, I'm gonna go and see about attorney.
Okay, which time are you, how much time are you thinking it's gonna take you to have an answer?
It all depends on how much it is to retain.
Got it, that's valid inquiry. So you're gonna need to make some phone calls. What I'm gonna do is I'm gonna grant the request to have your attorney withdrawn due to the breakdown in communication. I'm gonna set this for a new probable cause conference. Because of that, I'm gonna find good cause to go beyond the 21-day timeline because you have the right to have your preliminary examination within 21 days of your arraignment. You were arraigned on November 9th, and so your exam was scheduled for tomorrow, technically. I moved it to today due to my own family emergency. And so we'll go beyond that 21-day timeline. We'll give your mom some time to make some phone calls on your behalf and try to hire an attorney to represent you.
The question is, what if that possibility doesn't come into play? What happens if it goes on from here?
What do you mean? What if you can't afford to hire an attorney? Well, then he doesn't have an attorney. I guess he could try to make another request to court-appointed counsel, but I don't know if the public defender's office wants to play that game. If that's up to them, they're the ones who reviews and approve those. Yes, sir.
The reason I really didn't want him to be because like when doing the phone call, like he'll hang up the phone on me. Like, I'd be sitting there like we be talking, he'll just click out of the phone call. I'd be like that's real disrespectful, man. Like I'm trying to see what you talk about because I feel like you was like I didn't feel like you was
okay. If you felt like that your relationship with him was what the issue was, I would try to document that so that in case you need to ask or reapply, the public defender can take that office can take that into consideration, and maybe they will try to appoint you someone else. You can't say it's never happened before, it has, but I don't know what they're going to do in this case. Okay, sir. But you're requesting to have Mr. Feigelson removed so that you can hire counsel. So that's what we're going to do at this point. Okay.
So like then like and then because it's been people like it's been like people telling me like lawyers and stuff that I can but I can't even get on the kiosk machine or send a text message or nothing. Like when they say don't contact my baby mama, I did stop that, but it's like I can't contact nobody like to even try to give out some information to try to help with my case or fight my case.
Your Honor, he's called his mother 46 times since Judge Buchanan's order. As recently as 9 a.m. yesterday, not people on his behalf, him. So this thing of, oh, I can't access phones, he's not supposed to, he has been.
Yeah, I'm talking about my own phone line.
Okay, but the allegation is that you've made contact with your mom since November 17th, 46 times. So you can't come and tell me I can't get the name or of these attorneys to my mom. It's not beneficial to try the phone game because Mr. Feigelson's all night. This is what he's doing. Mr. Pfeiffer, I'm sorry, Mr. Pfeiffer all night is listening to phone calls, okay? So he's gonna know, just so you're clear, okay? So if you have names of potential attorneys that you want to jot down, Mr. Palmer can get you a piece of paper today. Give it to your mom. She's gonna be making these phone calls, and it's the holidays, so she's gonna want to make those quickly and try to find someone before they're sitting on the beach for the next 3 weeks. I don't know. But you need to get someone quickly. You have a 3,000 cash surety bond on one, 100,000, sorry, and 300,000 cash surety bond on the other. And you're gonna be sitting around until those are posted or until you can have this matter resolved. Do you have any other questions today? You seem like you do. While you think about that questions, I'm gonna remind you of the no contact order. There's a no contact order protecting the alleged victim in this matter. That being a Minnie James, you're not to have contact directly or indirectly. Indirectly would be if you asked your mom to call her. That would be a violation of your no contact order. It also could potentially put your mom at risk for being criminally charged. Do you understand that? Do you want your mom to be criminally charged and handcuffs and in a blue jumpsuit? So you don't want to potentially ask her to do something that's illegal. I'm sure she would never do it though. You don't want to do that, correct? Okay, so no contact, directly or indirectly. There again, your phone restrictions have been in place since the 17th. I don't feel like they need to be addressed at this time, but I'll leave that to Mr. Palmer if he wants to address bond or anything else at this time.
Your Honor, I guess, first of all, I will say, given that I've only known Mr. Jones about 45 minutes, I'm not in a position to make a significant bond argument. I understand, and I'm sure Mr. Pfeiffer has objections. I would ask that the court consider reinstating his phone privileges, at least for the purposes of contacting his mother. I would understand if it blocks the complainant witness. Obviously, I anticipate Mr. Pfeiffer's objection, but I will point out that Mr. Jones is now going to have to work on obtaining an attorney and a record for this, for both of these serious allegation files. So I'd ask for consider that modification.
I mean, I don't, he's called his mom 47 times since then, so why not just let him call his mom directly? So it's easier for you to trace while you're listening to videos.
Oh, it's not harder.
I know it's not. I'm happy to grant the request. Did you want to make an objection for the record, though?
I would ask that the court order that the victim's phone numbers be blocked by the jail.
I am going to order that the jail block the victim's phone numbers and that the defendant is allowed to make phone calls to his mother as she is helping to assist him with getting counsel. Mr. Feigelson has joined us. Mr. Feigelson, you have been removed from this case due to the break, or these cases due to the breakdown in the attorney-client relationship. And so bond in each file will continue. The no contact order has been reiterated and those will also continue. Any additional matters for the record?
Or one thing I'd like to have stated on the record for the benefit of Mr. Jones to help, let's say, hedge any further temptations. The people are fully prepared to bind over and try this case with or without the appearance of the victim. And that if she does not appear, that does not mean these charges go away. And that I personally have a very lengthy track record of doing so in all of these courts. I want to make that clear because I think there's some misconceptions and that might help deter any further criminal activity.
Okay, that is noted. For your benefit, Mr. Jones, did you have any questions, sir? For the court, you may have a question for Mr. Palmer, but I don't want you to ask me a question that Mr. Palmer should answer for you. But do you have any questions for the court?
Just two very quick. Did the court give the new, I know you said you were setting it for PCC.
Oh, no, we didn't. Let's do that.
It's gonna be January 6th at 1 p.m. for PCC.
January 6th at 1 p.m.
And PE is gonna be January 13th at 1 p.m.
January 13th, at what time?
Yeah, at 1 p.m.
We'll do the new preliminary examination date for January 13th at 1 p.m. Obviously, if you hire an attorney, we don't know what their schedule is. They may be in trial then. They'll notify the court and we'll get them new dates, but we're setting it for that date and time now to make sure we're on track and that we don't let this linger for too long. Do you have any questions, ma'am?
Yes, I got a question. When you said a lengthy track record, what kind of lengthy track record is he pertaining?
Oh, you can ask him that off the record.
Oh, okay.
Yeah, he's talking about a track record of him being able to get these convictions. That's what he's talking about.
Oh, okay, I thought you said legal track record.
Oh, yeah, no,
Not
no.
him, for me.
Oh, okay.
Yeah. Any other questions?
And yes, I do. And when, like you say, James was calling me, the prosecutor told his child, his baby mama, that I and him said we were going to kidnap the baby.
We don't want to get into this. We don't want to put all this on the record. Yeah, you don't want to do that.
Because I don't like the lies. Don't lie.
Yeah, I get it. You've not been charged with anything. You don't need to say anything that could potentially get you in trouble or even get him in trouble. I reminded him of, I don't even have a violation of his bond at this point. I don't know what's gonna come. But I have reminded him of what he is not to do while he is out or in on bond. And then what he doesn't want to encourage anyone else to do, because it could get him and some other people in trouble. Unless there's anything else for the record.
Just, I guess my only other point of clarification, I know that the court said that they were allowing Mr. Ferguson to withdraw. Does the court need paperwork or a motion or anything, or?
Yeah, I need to,
We have an order that we've used before. in our
Okay.
courts.
I was gonna say, it's not gonna be a substitution, but if you have an order, yeah, I need that and I can get it signed and place it on both of these files. You did take the dates, January 6th and January 13th.
I took the dates, so I
Okay.
can add those to the file.
Okay, and then also the order for the victim's phone numbers to be blocked in the jail, that will also go in.
I'll contact the jail and provide them.
Okay, very good. Any additional matters?
Not from the people.
Not from the.
You're all set. Thank you.
Thank you, Justin.
Thank you. No problem.
By the way, I worked with you in 21 years.
Oh, thank you for your service.
And one.
Good, Trine.
Yeah. Thanks, Judge. Have a good day. Sorry.
Have a good one.
Sorry for the car.
Oh, you're fine. I
I'm
heard
gonna
you
email
was-
you for a transcript of
Heard you was in
that.
court.
Straight up admitted.
Yes.
Calling her.
Hi, Lord. Let me write a note here.
Yeah.
Oh, you leaning over to talk to her?
I did call her.
Oh, I want to say something.
Okay.
Oh, because she absolutely said they're going to take it. They were talking about as soon as it gets out, they're going to take her child and run.
Listen, I have
I see Mr. Goodrich is here with Mr. Fisher. Do you need to speak privately with him?
Yes, I do, Your Honor.
Okay, I'll get you in a private meeting room. Fisher, Goodrich. And Mr. Abbott, who did you say?
I'm running on James Nicholas, Your Honor. He's going to waive the 21-day rule, He's being evaluated for specialty court.
Okay, we're on the record in the matter of the people of the state of Michigan versus, oh wait, no, we're not. Is he in custody?
He is in custody of the United States.
We're not on the record. Let's go get him. Okay, who do we have here?
Mr. Martin for sentencing, Your Honor.
Okay. We're on the record on that one. This is a matter of the people of the state of Michigan versus Sean Patrick Martin, file number 22-02503, counsel appearance.
Your Honor, good morning. Jared Austin appearing on behalf of Sean Martin. He stands present to my right.
How are you, Mr. Martin?
Quite well, Your Honor, and I'm sorry to hear about your family trouble. I hope it gets better soon.
It is already getting better, and so thank you for your concern, but yes, everything is looking upward. So today, however, is the date and time set for your sentencing.
Yes, ma'am.
And let's see here. I do have a pre-sentence report recommendation. It was prepared back on October 14, 2022. Did you get a copy of that?
I did, Your Honor, provided a copy of Mr. Martin. We have both reviewed.
Okay, any need to make additions, corrections, or deletions?
No, Your Honor.
You can address the court for sentencing.
Yes, thank you, Your Honor. Your Honor, Mr. Martin stands here. This is the first time he's ever been involved whatsoever in the criminal justice system. He acknowledges that he didn't behave appropriately on this day. I think Mr. Martin is going through some issues the court can see from the recent report. He has some mental health treatment, some medications that he takes. And those have since, my understanding, been kind of reevaluated and adjusted. So that may have played some part into why he was behaving seemingly out of character for him on this particular day. Mr. Martin does have a lot of stability in his life. He's married. He has family ties. He's gainfully employed. Works full time. And I think all of that suggests, Your Honor, as to what an anomaly this is, and also the likelihood that he is going to successfully complete whatever sentence the court imposes. If the court does place Mr. Martin on a term of probation, I believe that he would certainly be successful with that. He has not had any violations on his pretrial release. The court adopts a recommendation. I would ask that it not exceed the amount of time of probation that is being recommended, and I don't believe that any additional or upfront incarceration is warranted at this time. Thank you.
Thank you. Is he already engaging in mental health
Yes,
counseling?
ma'am.
Okay, where's that?
This is with Meridian West. I have since switched that from Carefree Medical, seeing as there are other issues that are semi-related to this, but not completely, that I will be taking care of after this as well.
Okay. Okay, so the assessment here indicates that he was a moderate low risk, but that the probation department did believe that he needed to have a mental health evaluation done, and it appeared that MRT would be appropriate. You indicated though that was there a change in his medication at that time, or is that what was going on?
Yes, Your Honor, during that time period, and I think that has subsequently changed since then. I think seems to have a more stabilizing effect on Mr. Martin.
Okay. I mean, you absolutely have nothing else on your criminal history.
I plan to keep it that way, Your Honor.
I hope that you do. I don't see any reason why you wouldn't. I think this was probably an isolated incident. And hopefully whatever medication you're on now, you are stable on, or stabilizing your moods a little bit better. Because of that, I am going to adopt the recommendation, but with some changes. I'm not going to do 9 months. I think that I can probably see what I need to see within 6 months. But I'm going to make it non-reporting probation. I want you to continue your treatment. For your mental health. And you said that was with Meridian?
Meridian West. Their actual name is about 10 miles long.
Okay, that's fine. You're gonna provide verification of your treatment to probation though, okay?
I will absolutely do that. I have record of it on my cellular phone. And they may feel free to call to follow up.
So I'll have them, that you verify with them monthly that you're continuing your treatment with your treatment provider. And I am going to order that you complete the moral reclamation program. Do you have any questions right now about probation?
No, Your Honor, I do not. My questions are for my counsel at this point, and him and I have already discussed moving forward.
Okay, very good. We're also going to give you this advice of rights as to probation so that you can review it with your attorney and then sign it.
Fair enough.
Is there a place for Mr. Martin that he needs to sign it?
It should be something on the bottom. What does it say there?
Don't see.
You can just have them sign on the bottom. They might have printed it inappropriately. It's usually a line there.
It's like there's a line with the date of the hearing, but I don't see a
Oh, yeah.
signature line.
Sounds good. Thank you.
You're very welcome.
Okay, and then there are some fines and costs, sir. There's a $75 crime victim rights fee that will be assessed for count 1 and count 2. As to count 1, there'll be a $50 state minimum cost assessed. So your total fines and costs will be $200. You can make monthly payments on that, okay?
Thank you, Your Honor. We will do our best to make sure those get taken care of. I have a few other things family-wise myself that are beginning to take precedence, which I was aware of prior to court.
Okay, very good. Will court also take precedent?
Yes.
Okay, very good. And so unless you have any questions for me, you are all set. Good luck. Make sure you stay compliant with your treatment.
Thank you.
And hopefully we won't have to see you on this side of the bench again, okay?
I hope not, Your Honor. I hope it's eventually over a lunch.
Thank you. Have a good one.
You as well.
Thank you, Judge.
And thank you.
Thank you. Okay, Mr. Goodrich, are you ready?
Yes, Your Honor, we are ready to proceed to Mr. Fisher's sentencing.
Thank you. We're on the record in the matter of the people of the state of Michigan versus Trevor Michael Fisher, file number 22-00579 FY. Council appearance.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Fisher today.
How are you, Mr. Fisher?
Good. You?
I'm doing pretty good. Today was the date and time that was set for sentencing. I do have a pre-sentence report that was prepared back on October 21st, 2022. Mr. Goodrich, did you receive a copy and go over with your client?
Yes, I did, Your Honor. The one change that we would have is actually a positive one. He is now employed at Flapjack in DeWitt. And he is earning $11 an hour there.
Okay. Very good. You can proceed with allocution.
Thank you, Your Honor. Your Honor, we think the recommendations in this case are fair. We would ask you to place him on a term of height of probation. He informed me that this week he started going to AANA meetings on his own. And basically he has had a drug and alcohol problem over the last several years, and he is anxious to treat it and get over it. He is now has a stable place to stay with his parents in the DeWitt area. So again, we would basically ask the court to follow the recommendations of probation here and place him in height of probation. Thank you.
Okay, thank you. I had an opportunity to review the report and the recommendation as well as his prior criminal history. I think the recommendation is appropriate. Says that he scored moderate high risk and high needs in employment, which he's addressed. Leisure activities, neighborhood problems, substance use, and responsivity domains. So we think that this term of probation will grant him an opportunity to address that, while also granting an opportunity to be or to receive status under HYTA. So that will be granted. There will be a sentence of 180 days, credit for 2 days. I'll suspend the balance of 178 days upon successful completion of 12 months of probation. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance without a valid prescription. Do you understand that?
Yes, ma'am.
Okay, you're going to be required to submit to random preliminary breath test and or your analysis, and you have to pay the fee for that, okay?
Okay.
You're not to be at any bars or nightclubs while out on probation. I'm going to order that you attend a 12-step meeting and provide verification as directed by your probation officer. But also order that you participate in outpatient substance abuse assessment and then follow the recommendations, okay?
Okay.
I'm going to order that you maintain employment while you are on probation.
All right.
Also, while on probation, there's a $30 per month oversight fee that you are responsible for.
Okay.
There's a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost.
Okay.
I'll waive discretionary fines and costs. Your total will be $485. And you can
All right.
make monthly payments on that, okay?
Okay.
Do you have any questions about either probation or fines and costs?
No, ma'am.
Your probation officer will make contact with you to go over this order. You'll have to review and sign it and get it back to the court, okay?
Okay.
Any additional matters for the record today?
No, Your Honor. Thank you.
Okay, Mr. Fisher, you're all set and good luck, okay, sir?
All right, ma'am.
Have a good. Who we have here? Okay. On the record in the matter of the people of the state of Michigan versus James Ryan Nicholas, file number 22-01514 FY, council appearance.
Thank you, Your Honor. Randall Berman on behalf of the people.
Good morning, Your Honor. John Abbott from the Public Defender's Office representing him today. I believe this is Sarah Donnelly's assignment, but she's unavailable.
Okay, today was the date and time set for a preliminary examination. But my understanding is there's a request to adjourn.
There is, Your Honor, Mr. Nicholas is being evaluated for specialty court in 54B or 54A. I'm not sure which one it is.
Specialty court,
Pardon?
it's the mental health court.
Mental health court, yes. And although looks from our notes here that he has not been present during previously scheduled preliminary exams, but never actually formally waived until London. That may not be true, but that's what it looks like from my notes.
He has the right to have within 21 days of arraignment.
Right.
He was arraigned. And he was given an exam date, and then he failed to appear. So he waived.
All right, so then we're all squared away with that.
Yeah. So, yeah, he was arraigned August 6th. He had a PCC of August 19th, preliminary exam of August 26th. August 19th, which is PCC date, his counsel had no communication with them. And then he didn't appear for this exam. We didn't see him again until October. So, yeah, that's all set. And I did note, I think in his last court date that he was being screened for mental health cards. I guess we're still waiting for that screening.
Is there a bond set yet in this case? Let's see.
The bond was set at 2,500 cash surety back on October 15th.
Okay, thank you.
No problem. And so we will adjourn this out another 30 days to have the assessment done.
January 6th, 9 a.m.
January 6th at 9 a.m.
Thank you.
No problem. Any additional matters for the record?
And on behalf of the people, Your Honor, thank you.
Not from the defense.
Thank you. You're all set for today. And Hernandez La Rosa. Afternoon.
It'll be an exam.
Wow, we're actually gonna have an exam. It's all 20 of these, huh? Was there someone else that I missed? No.
I believe Mr. Austin has a claim.
Your Honor, the only thing left, I think, was Mr. Hatton was in custody at Eaton County, participating, doing a plea, but my understanding is not brought over. I don't know if the matter is set at this point.
He was not brought over, so I did tell or instruct myself that they can reset him.
The 6th at 8:30.
The 6th of
January.
January 6th at 8:30.
Okay.
Okay. Sounds-
Thank you.
No problem. And then Mitchell. Did I handle that one?
Yes, you did, Your Honor. He
I
failed
did.
to appear. We were
That's
gonna-
right. Okay, I just did James Nicholas. I already did Fisher. Okay, well. Are we ready on Hernandez La Rosa?
I am, Your Honor. My office should be coming down right now.
Okay, give me just a quick minute and then I'll be ready too. Okay, we're on the record in the matter, the people of the state of Michigan versus Luis Hernandez La Rosa, file number 22-01718 FY, counsel here.
Brian Ring on behalf of the people. And Scott Nicole on behalf of Mr. Luis Hernandez La Rosa, who was present and standing to my right.
Okay, how are you, Mr. La Rosa?
I'm doing fine. Thank you.
Today is the date and time set for preliminary examination. Are we ready to proceed on this?
Prosecution is, Your Honor. Defense is as well.
Any preliminary matters?
Nothing from the people, Your Honor. Nothing from the defense, Your Honor.
Okay, call your first witness.
People call Officer Deon Walker.
You can have a seat, sir. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can have a seat there, officer. And if you could state your first and last name and spell them both.
Damon Pulver, DAMONPULVER.
You can proceed, counsel.
Thank you. Officer Pulver, where do you work? The Lansing Police Department. How long have you worked there? I worked there for a little over 2 years.
In what capacity do you work? With the Lansing Police
I
Department?
work as a police officer.
Do you work on road patrol?
I do.
Were you assigned to that? Were you assigned to road patrol on the second, excuse me. Were you assigned to road patrol on February 21st, 2020?
I was.
2022, sorry. And on that day, were you dispatched to 604 Mount Hope?
West Mount Hope, correct.
Is that in the city of Lansing?
It is.
Is that in Ingham County, Michigan?
It is.
So why were you dispatched to that address?
I was dispatched there due to the caller calling in saying that her ex was there and was unwanted.
Did you arrive at 604 West Mount Hope?
I did.
And were there other officers already there?
There were.
Who was there?
There was another officer, Officer Chang, was on scene before I showed up.
And so what did you do when you showed up?
So when I showed up, Officer Chang said that he had already spoken to the caller, who said that.
Objection, Your Honor, here's that.
Any response to the?
I'll rephrase, Your Honor.
Thank you.
Without
Objection
saying what,
sustained.
without saying what Officer Trine told you, what did you do when you showed up?
So when I arrived on scene, we looked for Mr. La Rosa. The caller said that he wasn't in the house anymore and just wanted the garage checked.
And did you check the garage?
I did check the garage.
And what did you find in the garage?
When I went to the garage, the door was unlocked. So I opened the door and inside was Mr. La Rosa sitting on a couch.
And how close was the garage to the house?
It was a detached garage, so it was probably about maybe 20 yards away from the house.
What did the garage look like inside?
It was very cluttered. There was items all over inside of it, and it would have been very difficult to try to get inside.
And how far, you estimated about how far back in the garage Mr. La Rosa was?
Maybe about 15 feet.
What was he doing in the garage?
He was just sitting on a couch.
Were you in uniform?
I was.
Was Officer Chang in uniform?
He was.
Was any other officer on scene there as well?
In the end, I think there was probably about 6 officers that showed up on scene, all of which were in fully marked police uniforms.
Who was with you at the garage? Which officers were with you at the garage? The
It
initial
was
contact?
myself and Officer Chang made the initial contact.
And so what happened when you made that initial contact?
When I made the initial contact, I introduced myself as a Lansing police officer and asked the gentleman, what his name was and trying to figure out who he was and make sure that he was a person that was the unwanted subject. And he was pretty uncooperative and was obviously intoxicated.
And do you know if Mr. La Rosa lived at that address?
So after I made that initial contact with him and he was uncooperative, then I personally went back to the caller, made contact with her myself, and just wanted to verify everything with her because all we had was his name originally. So I just wanted to verify with her, if he had legal standing there or not. And she told me that he had moved out.
Objection, Your Honor, hearsay. Your Honor, it goes to the effect on the listener why he attempted to remove Mr. La Rosa from. He would have no reason to remove Mr. La Rosa if he was legally there unless somebody informed him that he was not there, Your Honor.
So it's not being offered for the truth of the matter asserted.
Yes, Your Honor.
It's not, or it is?
It's not, Your Honor. It's why
Okay.
he's being, why he was. removed.
Objection is overruled. Thank you.
Okay, so you had stated that he did not, you were told that he did not live there.
Correct.
And so did you make contact again with Mr. La Rosa?
Yes, I made contact with him again and he said that he lived there and I asked him if he had some sort of identification or some sort of proof that showed that he did live there. And he completely ignored me and kind of just brushed it off. So, yeah.
During the second contact, what other officers were there at the garage with you?
There was another officer, Officer Pellegrino. And he also made some communication with him as well.
Was Officer Pellegrino and was Officer Pellegrino in uniform at the time?
He was.
So once you found out, once he was uncooperative, what did you do next?
So once he was uncooperative, had no way of proving that he had legal residency there at the address. Also, when I had made contact with the caller, I went to my patrol vehicle and ran Mr. La Rosa and Lean, in which he came back with a domestic violence warrant out of Lansing. So when we went back there to make contact with him, he was uncooperative, but we ended up telling him that he was under arrest for his domestic violence warrant.
So you were going to place him under arrest for that warrant?
Correct.
And then did you eventually have to go in to get Mr. La Rosa?
We did. We were outside of the garage for probably about maybe 5-ish minutes trying to communicate with him to just come out and say, we told him multiple times that he was under arrest and that we were the Lansing Police Department, and he refused every time to get him.
So what happened when you went in to go get him?
When we went in to go get him, we walked in, we had to move around a bunch of stuff to end up getting over to him, but I grabbed onto him and told him to stand up, but he refused to stand up. So me and another officer had to physically pull him up and take him out of the garage.
And when you began to take him out of the garage, what happened then?
When we got him out of the garage, we went over to the house. He was still uncooperative and moving around, so we still had to place him in handcuffs at that point. So when we got over to the house, I pinned him up against the house with one of my shoulders and tried getting his arm behind his back, and he kept pulling his arms away from me. I told him multiple times to put his hands behind his back, and he refused to do that.
And that person that you pulled out of the garage, are they in this courtroom today?
They are.
Can you please point to them and describe something they're wearing?
It's this gentleman right over here with the brown leather jacket.
Let the record reflect that the witness has identified the defendant.
Any objection to ID?
No objection for the purpose of preliminary.
Identification is noted.
And so he was pulling away when you said he was pulling away when you were trying to place him in handcuffs?
Correct.
Did you eventually get him in handcuffs?
We did eventually get him in handcuffs.
Once you got him in handcuffs, what did you do after that?
After we got him in handcuffs, then we escorted him to one of our patrol vehicles. Once we got there, then we conducted a search of him. The entire way that we were walking over there, he was pulling away from us and trying to basically get away from us. So we get to the car and he keeps thrashing around. So again, we had to pin him up against the car. While we were doing that, I used one of my arms to put underneath his to keep him from moving and keep his arms away from his waistband so we could conduct a thorough search. During that process, he turned over into me and lifted up my arm above my shoulder, which ended up causing a bunch of pain in my shoulder.
Was it your right arm or your left arm that was?
Sorry about that. It was my left arm.
And you said it overextended past your shoulder?
Yes. So the way that he did it, he was actually trying to assault one of the other officers that was helping do the search.
Who was he
headbutt him.
trying to assault?
Officer Pellegrino.
And how was he trying to assault Officer Pellegrino?
He was turning in and trying to lean into headbutt him as he was trying to search him.
And you saw all this as you were trying to detain him?
I did.
And did you eventually get him in the vehicle?
We did eventually get him thoroughly searched into the vehicle.
And how did you have to put him in the vehicle?
I think he just sat in. I don't remember us having to do anything egregious to get him into the car, but
you said you injured your shoulder. Did you hear your shoulder pop?
Yes, I felt it pop multiple times.
And what did you do after your shoulder popped? Did you
Sorry, are you okay? Okay, thank you.
Did you have to seek medical treatment for that shoulder?
I did. I had to go to Sparrow Hospital.
And were you out of work at any point for your injury?
Yes, I wasn't allowed to return to work for about a week.
Nothing further this time. Thank you.
Do it, processing.
Officer Pulver, you stated, so you made contact with Mr. Hernandez La Rosa originally at the garage?
I did.
Right, and your testimony that he told you that he lived there?
That's what he said.
Okay. And other than the statement of the original caller, do you have any information to believe that would have corroborated whether he lived there or not, or is it just her word, his word?
Her word, her also saying that there was a PPO that they had in place, but that, again, I couldn't confirm that. So outside of that, there was no like paperwork or anything that I could look at.
Okay. So it's entirely possible that he did still live there at the time, correct?
I don't know. I didn't look through the house, so I couldn't tell if he had anything inside of it.
And you said you ran him through lien and you found a warrant.
I did.
And when said Mr. La Rosa seemed intoxicated.
Correct.
What made you believe that Mr. La Rosa was intoxicated?
He was slurring his words and unable to make clear sentences.
And so then you went in and you had to move some stuff and you picked him up off the couch?
Me and another officer had to pick him up, yes.
And got him to the side of the house. You put him up against the side of the house so you could put him in handcuffs, correct? You said he resisted by not putting his arm behind his back, correct?
Right, he was pulling his arms in toward his waistband.
Okay. How many officers were assisting you at that point in time?
At that point, there was probably at least 4, maybe 5.
And did Mr. And at that point, you had him pinned up against the house?
Yes, I think it was me and another officer. That did, yeah.
Okay. And do you remember which side of Mr. La Rosa you were on?
I was on his left side.
And there was another officer on his right side?
Yeah.
So fair to say the two of you had him in a position where it would have been difficult for him to get away from you?
Yeah.
And then you were able to get him into handcuffs?
After about a minute or so of him pulling away and thrashing, then yes, we were able to get him in handcuffs.
Once you had him in handcuffs, is there any reason you didn't search him when you had him against the side of the house?
We wanted to move away from the house, and I think we just kind of decided we wanted to search him at the car. So I don't remember there being a specific reason.
Okay. How many officers helped you direct Mr. La Rosa from the house to the car?
It was me and one other officer.
Was he able to ever get out of your grasp?
No, he wasn't.
Okay. And then you had him against patrol vehicle, and then you conducted the search.
Correct.
And you stated that at some point he turned his body and leaned towards Officer Pellegrino.
I wouldn't say he leaned. He made more of an aggressive turn into him with his head leaning forward.
Okay. And sounds like you interpreted that as an attempt to headbutt Officer Pellegrino.
Yes.
Was he trying to pull his arm at the same time he's doing that?
So as he was doing that, so his hand was behind his back and he lifted up that left elbow, which my arm was underneath, and caught my elbow and hyperextended my elbow.
Okay. Is it possible that his head moving is part of the attempt to pull his arms away from you?
He was aggressively yelling at Officer Pellegrino, so I don't think that he was just trying to thrash around. I think that he was intentionally trying to assault a police officer.
But you don't actually know what he was trying to do. You don't know whether he was trying to assault him or was just trying to get away from you.
He didn't specifically say, I'm going to assault a police officer and do it, but his actions are different than what a normal person resisting arrest would be doing.
Okay. But to be fair, Mr. La Rosa at that time had multiple officers on him?
There were 2 officers that were on him. Yes,
And he was heavily intoxicated?
he was intoxicated.
Fair to say that intoxication affects people's perception, people's ability to hear and understand what's going on?
Sure.
And then you said, once you got him searched, got him into the car, nothing additional you had to do to get him into your vehicle?
After that, I had to go to the hospital, so I wasn't there for any of the booking or lodging or sitting with him at the hospital, so I don't know.
I'm just talking about getting him in the car.
Getting him into the car, I don't remember there being anything intense that happened, no.
Okay. Sat in the car and everything, and then you went to the hospital and other officers took him?
Yes.
Was he put in your patrol vehicle or somebody else's?
It was somebody else's patrol car.
Do you know whose patrol car it was?
I do.
You wrote a report on this incident?
I did.
Is there any reason you wouldn't mention anything about this alleged headbutt in your report?
So I believe it was in my report. I'd have to review it, but I don't know if it makes a difference, but there was no actual contact.
I'll withdraw the question.
So
Yep, no, okay. I have no further question.
Redirect.
Very briefly, Your Honor.
So why were you removing him from the garage? I was removing him from the garage because he had a domestic violence.
And why did so many officers have to help?
So many officers had to help because he's a large person. He had a lot of coats on, but we need a lot of officers to help with the searching. He's a lot taller than the other officers that were on scene and weighed a lot more than the other officers that were there.
Fair to say that he weighs a lot more than you and is a lot taller than you?
Correct.
No further question, Your Honor. Thank you.
Yes, but it's the excuse.
Yes, Your Honor. Thank you.
Thank you, Officer Fulber.
Thank you, Your Honor.
You can call your next witness.
You were arrested this time, Your Honor. Thank you.
Is the defense calling any witnesses today?
No, Your Honor.
Okay, you can proceed to argument.
Thank you, Your Honor. Your Honor, Officer Pellegrino, Officer Pulver told us that he was there on the 21st and 22nd, rolled over into the 22nd of February 2022 at 604 West Mount Hope in the city of Lansing. He was there on a call for an unwanted. When he spoke with the homeowner, the defendant had no reason to be there. He then made contact with the defendant who was posted up in the garage, in the detached garage in the back, sitting in the back. He ran the defendant's name through lean and he had a valid arrest warrant. He was there in a fully marked police car, police uniform, and he gave lawful commands of the defendant to stand up and come out because he was under arrest. Officer Pellegrino was there with him along with Officer Chang. They were also all in uniform, also giving lawful commands for the defendant to remove himself because he was under arrest. At this time, the defendant refused to stand up. The defendant refused to come out. So officers made the decision to go in and get him under that arrest warrant that they had, Your Honor. So when officers went in, it took multiple officers to get him up off the couch because he kept refusing. Officer Pellegrino and Officer Pulver began to remove him from the sofa. He pulled away. He resisted multiple times. They were finally able to get him out. They had him up against the wall. They got finally able to get him in handcuffs after he continued resistance at that point, Your Honor. They managed to get him back to the vehicle. When they escorted him back to the vehicle, he turned toward Officer Pellegrino in an attempt to headbutt Officer Pellegrino, which was witnessed by Officer Pulver. Officer Pulver's elbow then moved up and extended past it where its natural point and popped out of socket, causing Officer Pulver to have to go to the hospital and seek medical treatment and be off the road for at least a week, Your Honor. At this time, Your Honor, people believe we have met our burden. I would ask that the court bind over on count 1 and count 2 in the complaint, Your Honor. Thank you.
Yes, Your Honor. Just briefly, I would suggest that the court not consider whether or not Mr. La Rosa had any legal right to be there. That's something that was not offered truth of the matter asserted and therefore can't be argued as part of the facts necessary to bind the case over. Beyond that, I would leave it to the discretion of the court, understanding, of course, that we are working with a probable cause standard here and what the evidence are with this charge. And beyond that, I would leave it to the discretion of the court as to whether or not court believes that people have met their burden.
Thank you. Today was the date and time set for preliminary examination, and the burden is squarely upon the prosecution today to establish that there's sufficient facts to support probable cause that a crime was committed and probable cause to charge you, Mr. Hernandez La Rosa, with the crime. Probable cause is a burden that requires more than mere suspicion that a crime was committed, but it does not require as much information as would be needed to prove your guilt beyond a reasonable doubt at trial. It's a relatively low and flexible burden. Based on the information that the court has heard here today, the court has to make a determination as to whether or not there's sufficient probable cause as to count 1 and 2 of a police officer assaulting, resisting, and obstructing. The court, looking at the jury instructions, whether or not he had a lawful right to be in the property really is not an element of these charges. The officer testified that they reported to the address of 604 West Mount Hope, City of Lansing, Ingham County, State of Michigan, on February 21st, 2022, in response to a unwanted person in the home, or a complaint of an unwanted person. And in investigating that, they searched the garage, and they saw the person they identified as Mr. Luis Orlando Hernandez La Rosa in the garage, sitting on a sofa or on a couch, and that there was communication or questions posed to Mr. La Rosa, but that he refused to respond, which he had the right to do. Whether or not he had the right to be in that property at that time is unclear, but in investigating, Mr. La Rosa, probably trying to see if he had a lawful right to be there, since he wouldn't respond. They searched and leaned and noticed that he had a warrant, a valid warrant for domestic violence, which now gives the officers cause to take him into custody. Officers testified that during their attempt to take him into custody, the defendant resisted and pulled and failed to comply with their lawful orders, pulling away the entire time. And at one point, I think he turned his body in such a way that Mr. Officer Colbert states that he believed that he was going to headbutt another officer, but that also it caused Officer Colbert to somehow dislocate or hyperextend his shoulder. Based on the information heard today, I think the court believes that there is sufficient probable cause to satisfy count 1 and count 2. Those will both be bound over to the circuit court for further prosecution for a bind over date of December 14th. You do not need to appear in court on December 14th. That's the date they get to file from this court at the circuit court. Your next court date will be in circuit court. It will be a pretrial. You and Mr. Nickel will be made aware of that date, okay? You have any questions today, sir? Any questions for the court? Okay. On in this matter was set at 2,000 personal recognizance, and that will continue. Any additional matters for the record today?
Nothing from the people. Thank you, Your Honor.
Nothing from the defense, Your Honor. Thank you.
Thank you. You're all set. Thank you.
Okay. That's the number I have in our system. Yeah. Just give me a second to pack up and then I'll be. No, there isn't any paperwork.
Some more ink in here when you get a
The next
chance.
piece, that's gonna come from the circuit court. So on December 14th, when we get the case, they'll set a pretrial. So I will tell you.
Oh, you got.
Yeah, so I'll get notice and then I'll email it.
Okay. Okay. Thank you.
So have a seat. I'll give her a call.
Okay. Thank you.
Make sure she comes.
Thank
pick
you.
up.
No, Mr. Berman was.
I'm gonna do all my stuff, right?